So what happens between an arrest and a trial? In Georgia, once a person is arrested, he has a right to a first appearance before a judge within 72 hours. Glenn versus the state reminds that at the time of the American Revolution, under the common law, these first appearances were used to double-check probable cause. The justices wrote that, when arrested pursuant to a warrant, the accused was to be brought to a justice of the peace who, after a hearing, would examine the accused without oath and the witnesses under oath and either completely discharge the accused or set a reasonable bail for bailable offenses or hold him in jail pending trial for non-bailable offenses. So basically, the accused got a chance to make his case and didn't even have to swear he was telling the truth. It was basically, see if you can come up with a reason we should let you go, and if you come up with a valid reason, even an untrue reason will let you go. Of course, this is also not happening today. In modern first appearances, the judge gives the accused a list of charges without any explanation of what he was accused of doing to supposedly commit those crimes, sets or denies his bail, and sends him right back to his cell. Whatever the police said is just presumed to be true. Defendants don't get to offer any defense, and don't even get to have a lawyer at their first appearance. And that's not some harmless thing. If you had a good reputation before being the victim of an arrest, you'll probably instantly lose it afterward. As soon as a person is arrested, the newspapers will report it, and then the person's mugshot will be available to the public to distribute on the internet. If you sit in jail for very long, you'll probably lose your job, and then with your mugshot floating around online, you'll probably have a hard time getting another one. Most people are ignorant of how broken the system is, so they'll continue to punish victims of wrongful arrests over and over again. The moment a person is arrested, that person's life will fundamentally change forever, whether he deserves it or not, and the longer the case is dragged out, the greater the harm. At this point, presuming that the judge set a bail that the accused can afford, he should be able to get out of jail. But bails are often more than the accused can pay. If the accused can't pay, he might get the help of a bondsman. The bond is essentially a loan in which the bondsman pays the bail, and then the accused pays the bondsman a fee for his service. When the accused returns for trial, the bondsman gets his money back and gets to keep the fee. With the bondsman, the accused, who has had absolutely no opportunity to defend himself, pays a non-refundable fee of hundreds or thousands of dollars, whether he is ultimately found guilty or not. At the next check, the prosecutor is supposed to review the evidence and apply discretion, deciding not to pursue a charge if it doesn't have sufficient evidence to prove it beyond any reasonable doubt. But prosecutors almost never use this discretion to dismiss charges unless it is to help their friends. Prosecutors will usually try to represent and protect the police by wringing a conviction out of a person whether he deserves it or not. The next step is where the people come in. In felony cases, the risk of going to trial is high, so before a prosecutor can bring the accusation to trial, he has to get the approval of the grand jury. In Georgia, the grand jury is a group of 16 to 24 citizens whose job is to protect the people by ensuring the prosecutors don't go to trial with weak cases. The proceedings are secret, so it is hard to know exactly what goes on in the grand jury room, but we do know that the process doesn't work very well. While the prosecutor gets to tell the police side of the story to the grand jury, the accused doesn't get to tell his side or cross-examine the witnesses, and the prosecutor can bring, or fail to bring, whatever evidence he chooses. I would think that in the Freeman case, Suzanne Boykin probably did not show the grand jury the Home Depot security video proving that Freeman did not back up at Donnie Nelson, because if she had, they almost certainly would not have indicted. The grand jurors should be presuming the innocence of the accused and demanding that the police prove their cases. After all, their entire purpose is to protect the people from false accusations. But in practice, they tend to sign anything that the prosecutor shows them. There's an old saying among lawyers, you can indict a ham sandwich. In the Home Depot case, we know that the grand jurors met on October 7th, 2024, and that they handed down 22 indictments that day. That means that even if they worked a full 8-hour day, they could have spent no more than 22 minutes on average for each case before handing down an indictment. Even speaking at hyperspeed and examining only a fraction of the evidence, Mr. Pipsqueak Season 1, the Tacoma Home Depot police scandal, is longer than that, so it is highly unlikely that the grand jury gave this case its due. You probably know more about this case than the grand jury did. So you've been told that there is a rigorous legal process to protect the rights of the accused before a case goes to trial. But it just isn't true. At every step, everyone presumes that the police are telling the truth, that the previous steps did their job, and that even if they get it wrong, the next step in the process will clean the mess up. But since everyone in the chain thinks that someone else is giving the accused adequate protection, no one is. All of the checks on police power have effectively eroded away, resulting in cases like Elder Freeman's going before the jury, despite obvious, undeniable evidence of innocence. Once a defendant has been indicted, he can expect to spend months or years awaiting trial. From here, the risk of the trial penalty leaves most defendants at the mercy of the prosecutor, and in the few cases that actually go to trial, the fate of the accused rests solely in the hands of the jury. And don't forget, Elder Freeman will be at the Stevens County Courthouse on September 10th, 2025 at 9 a.m., and I want you to be there. We also still need just a few more signatures on the petition to free Elder Freeman, so if you haven't signed yet, go do it! I'm Mr. Pipsqueak signing off, and remember, you should never talk to police without your parents and a lawyer present.